the session, the Honorable Judge Rush will preside.
See, I believe we have an announcement in case state versus Taylor, is that correct?
Yes, Your Honor.
I need to let the fifth come around, please.
Judge, if I could, I need to let him sign this form.
Big fast.
But he sat down here.
Yes,
sir.
sir.
Had this matter gone to trial, the state would have presented evidence that would have shown, with respect to count one, that on or about July 22nd, 2008, Julie Rasmussen was a former client and friend of the defendant, when she approached him and asked for advice on investing around $10,000, and this $10,000 was the amount that remained on the proceeds from a personal injury settlement. And she told the defendant she was interested in investing this money so she could provide for her daughter's education. And the defendant informed Ms. Rasmussen that he had a special investment program that was open to some limited number of people, and that if she invested, she could make a lot of money, and at least more than the interest that she was getting on the certificate of deposit where the money was. And based on what the defendant told Ms. Rasmussen, she cashed out the certificate of deposit, incurred a penalty, gave what money there was to the defendant to invest. The defendant did not in fact invest the money, but almost immediately converted it to his own use and used it to pay various personal expenses and the like. With respect to count two, the defendant would have shown, or the state would have shown, that in 2008, Ms. Melissa Deering retained the defendant to represent her in a workers' compensation case. She retained him as her attorney after having dismissed other attorneys who had worked on the case. The defendant was able to negotiate a court-approved settlement in the case. He paid Ms. Deering part of her money, and he was also supposed to pay money under the order to the other lawyers. And what he did is, instead of paying the other lawyers, he converted that money to his personal use, and in fact also shorted Ms. Deering on her money. And during this period, he finally paid the lawyers, but never paid her what was remaining on the settlement. With respect to count six, in December of 2008, the defendant approached Ms. Colleen Burns and asked to borrow money. He told her that he needed to borrow the money because he was in a limited investment program and he needed these proceeds to become involved. All total, the defendant, Ms. Burns loaned the defendant $77,927.57. In fact, what the defendant needed the money for was he had some shortages in trust accounts from prior misappropriations of money to personal expense, and he needed to cover those shortages, and there was no loan program at all. Then with respect to counts 8, 10, and 11, over the summer of 2010, the defendant, who was then a juvenile court judge, was soliciting funds for what was known as the Foundations of American Law display. This was supposed to be some plaques commemorating the basis of American law, the Constitution, the Declaration of Independence, the Bill of Rights, and the like. And he made the solicitations at various places, including East Rogersville Baptist Church, and during one of the services, he was brought in to give his presentation. A collection was taken up of approximately $1,500 on that one. He also received contributions from Elam Baptist Church and from Cellular Communications here in Rogersville. Within days after receiving that money, at first from the trust account, it was paid out to his operating account, and then it was also used to pay his mortgage and other personal expenses. Had this gone to trial, the state would have shown that all this occurred in Hawkins County.
Mr. Taylor, you come around to the podium and raise your right hand, please. You solemnly swear the testimony about to give the truth, the whole truth, and nothing but the truth.
I do, Your Honor.
How old are you, sir, and how much education do you have?
41 years old, Juris Doctor degree.
Do you understand that you're charged with the C felony of theft, punishable not less than 3 or more than 15 years Department of Corrections, as well as a series of D felonies, theft, which is punishable not less than 2 or more than 4 years Department of Corrections?
Yes, Your Honor.
You understand you have a right to plead not guilty and have a right to be tried by a jury?
Yes, Your Honor.
Do you understand that then the jury will determine whether you're guilty or not guilty? Having explained those rights to you, do you voluntarily waive or give up your right to a trial by jury?
I do, Your Honor.
You understand by giving up your right to a trial by jury, you're also giving up your right to an appeal.
Yes, sir.
And do you understand that by your plea guilty, you may be asked questions about this event while you're under oath, and your answers can be used against you in the prosecution for perjury if you make a false statement?
Yes, sir.
And do you understand that by your plea guilty, or is your plea not no contest, is that correct?
That's on count 1 only.
On count 1, but by your plea guilty, the offenses, they can be used against you in subsequent prosecution to increase or enhance the minimum sentence that you might receive.
Yes, Your Honor.
And that by your plea guilty, that's the strongest evidence available against you, and that you're stipulating there's a factual basis for this conviction as announced by the District Attorney General. And what is the state's recommended sentences?
Your Honor, with respect to count 1, the state is recommending 3 years, split confinement, 1 year to serve 50%. With respect to count 2, which is amended to a D felony, the state is recommending 2 years suspended concurrent with count 1. With respect to count 6, which is amended down to a C felony, the state is recommending another 3 years, 1 year split confinement concurrent with 1 and 2. With respect to counts 8, 10, and 11, 2 years each on those, suspended, all concurrent with everything else. In addition, with respect to count 1, restitution in the amount of $10,000. On count 2, restitution in the amount of $8,283.36, or 26 cents, I'm sorry, Your Honor. With respect to count 6, restitution in the amount of $50,000. With respect to counts, let's see here, 8 would be restitution in the amount of $1,500. Counts 10 and 11 will be restitution of $1,000 each. And in addition, on counts 8, 10, and 11 is 600 hours of community service.
How does this sentence run with respect to the Davidson County?
It is consecutive to Davidson County, Your Honor.
Mr. Taylor, do you understand those that would be your plea?
Yes, Your Honor.
Do you have any questions about this sentence?
I do not, Your Honor.
Do you understand this sentence?
I do, Your Honor.
Your Honor, just for the record, not to interrupt the court, that would be a year to be served 50% with no more than 6 months service. And also, in speaking with the state's attorney's office, these restitution numbers, if we are able to communicate with the individuals that are represented by counsel or themselves and come up with a number that is not specifically in the judgment here today, those will be amended at a later date to reflect the actual amount.
Yes, sir, I understand. To this indictment, how do you plead guilty or not guilty or no contest? To count 1, you plead no contest, is that correct?
That's correct, Your Honor.
On the remaining counts, how do you plead guilty or not guilty?
Guilty.
James F. Taylor, on your waiving your right to trial by jury, entering a plea of no contest in count 1, and your plea of guilty to count 2, 6, 8, 10, and 11. The court hereby finds you guilty. Is there anything else?
May I make just one statement, Your Honor?
Yes.
In regard to the foundation display money, all of those monies last fall were put in the form of a cashier's check made payable to the American Legion for them to hold and act as trustee. And I just want to make clear that in addition to the 3 counts that have been referenced here today, that all of those monies that were collected are going to be returned, not just the 3 counts that were referenced here today. I just wanted to make that statement.
All right, thank you. I believe this grant's forwarded back to the manager of the meeting.
Thank you, Judge.
All right, thank you, Your Honor.
Ma'am, I cannot hear you.
Can I speak for Mr. Taylor Lee's room?
Oh,
I need him to say, I want to make a victim impact statement. I'm Lisa Deering,
all right.
and I doesn't need to be in here while I make that statement.
No, ma'am. You can tell the court what you might like to say.
Thank you.
Like for, is that there, Your Honor?
Yes.
Mr. Taylor, I suffered horribly, was chemically injured, and almost died from 2 chemical exposures and 2 toxic chemical exposures at work. One of your victims was
But Mr. Taylor, only expected cause that.
Yeah, how did this
Mr. Taylor
crime?
stole $32,254.74 of my workers' comp money.
Yes, ma'am.
And then attorney, David Dunaway told him to give me $2,000, and he stole that.
He's pled guilty.
Yes, we
To the
understand.
$32,254.74? Where is that? He pled guilty to $8,000.
Judge Sweat, all of this, I think I understand that this has affected you tremendously, emotionally, and financially.
Horribly.
And I appreciate your comments.
Okay, thank you.
You're welcome. Thank you. We'll stand in recess.
All right. Court's adjourned.
Just for Hawkins County, then.
Hawkins County, he got 3 years, which is called a split sentence, meaning a year to serve, and then probation. So he'll have that plus community service, plus restitution.
So he has one year that he must.
Yes.
1 year of prison.
Yes.
With a 50% eligibility.
Right.
Okay. And then 2 more years of probation.
Yes.
Consecutive to what did he get
In Davidson County is 3 years and another 10 of probation.
Okay. So altogether, what is he going to?
He'll have what's called an effective sentence when you count jail and probation is 16 years.
Okay.
In addition, he's lost his law license and cannot get it back during the term of probation.
And of those 16 years, how much jail time does he have?
It's going to depend on how they calculate it at the institution, and I'm not as familiar with that.
But not including the institution, but based on...
It would be a 4-year sentence.
4 years altogether.
4 years to serve.
Okay, but he's eligible for early release.
Yes, yes. He's a nonviolent offender.
Yeah. Okay.